Now I am going to dictate a legal passage based on Kolkata High Court judgments on tenancy issues at the rate of 120 words per minute. Let's start. The civil judge exercising jurisdiction under Section 7 of the 1997 Act does not have the jurisdiction to entertain any application for extension of time to deposit the amount adjudicated by the original order passed under subsection 7 within bracket 2 after expiry of the period stipulated by the original order. Stop. A close scrutiny of Section 7 of the West Bengal Premises Tenancy Act 1997 would reveal that there is nothing in the section providing extension of time or condonation of default of course under the proviso to subsection within bracket 2 of Section 7. The court is vested with power to allow an extension of time only once, and the period of such extension shall not exceed 2 months. Thus, the time limits specified in clauses B and C of subsection within bracket 1 as well as in subsection within bracket 2 and the proviso to the said subsection are conclusive and mandatory. Such time limits cannot be extended or delay in default cannot be condoned. Stop. In our view, even availability of accommodation in the flat held by the landlord's son cannot be regarded as an alternative suitable accommodation for the plaintiff, as the plaintiff cannot be compelled to move to his son's flat when he has his own flat in the suit house. The prayers in the plaintiff filed by the appellant indicate that the appellant is seeking a declaration of his title vis-a-vis the suit property. Such a declaration can obviously not be granted by the controller, who is only empowered to ascertain which part of the premises are tenanted and which part is in occupation of the subtenant. Stop. It would be more appropriate that the right of a landlord to recover possession of the tenanted premises from the trespasser who has forcibly disposed the tenant be seen as a right conferred by the expression he or any person claiming through him may be should recover possession thereof, appearing in Section 6 within bracket 1 of the said Act. The disposition has to be of the person in possession, but the action may be instituted by a person who has been dispossessed or by any person claiming through the person who has been dispossessed. The landlord of the dispossessed tenant can in such circumstances and by virtue of the locus recognized in the relevant expression be entitled to recover possession from the trespasser who has forcibly dispossessed the tenant otherwise than in due course of law. Section 6 of the West Bengal Premises Tenancy Act 1997 does not contemplate any notice to be given to the tenant when the tenancy has been extinguished in the above manner. Notice is required when eviction is sought on one or more of the grounds mentioned in Section 6 of the said Act. Stop. None of these judgments have laid down the contrary proposition so far as the power of the appellate court to direct the appellant to pay the higher amount as occupational charges for enjoying an order of stay of the execution proceeding pending the appeal. The quantum of occupational charges is not static but depends upon the various factors which could be reasonably ascertained from the aforesaid decisions. Though the appellate court is within its power and jurisdiction to direct the appellant to pay the occupational charges at the prevalent market rent, but at the same time the court should not arbitrarily fix the quantum which in other way operate harshly upon the appellant and the order appears to be punitive and in terrorem in absence of any material before the appellate court on the prevalent market rent, the appellate court can apply robust common sense, the common knowledge of human affairs and events gained by the judicial experience and judicially noticeable facts. Stop. Thank you.